Hi everybody, and welcome to this webinar on understanding the fixed cost regime. I have to say, when Anirudh and I put this in the diary a few months ago, I think calling it understanding the fixed cost regime was a little bit ambitious. We didn't think that 3 weeks out there would still be consultations finishing, judicial reviews being issued and no guidance available, but we'll see how far we can get with that. So I'm going to start off with an overview to the main changes, an introduction to the new concept of complexity banding, and then take a bit of a closer look at the fast track and what those changes are going to be. And then Anirudh's going to take us through the new intermediate track and the complexity banding there, and then look at the ways in which it's possible to either increase or decrease the fixed costs available, and as well as having a quick look at the judicial review that's currently ongoing against the regime. So that's the statutory instrument that gives effect to this regime. It says in force 1st of October 2023, as I've already said, and I'm sure you're very aware, there are ongoing challenges to the regime. The Ministry of Justice closed a consultation on it just last week. And there are a lot of objections and issues being raised with it. Despite that, and despite a lot of the legal profession's hopes that it would be postponed further, it seems unlikely at this stage that it is actually going to be postponed. We're less than 3 weeks out. It seems very much as though the Ministry of Justice is going to just crack on, as it were, and we'll have to deal with the issues as they come. So we all need to be ready for the 1st of October and know how that applies to different types of claims that will be caught. So in general, claims issued on or after the 1st of October will be caught, with the exception of personal injury claims. For non-disease personal injury claims, it's where the cause of action accrues on or after the 1st of October. And then for disease claims, it's where a letter of claim hasn't been sent before the 1st of October. So for all those claims, we need to have 1st of October in mind, and then we just need to see exactly how it's caught depending on the type of claim. And it does mean that for personal injury claims, there's going to be a bit more of a lag until these really start kicking in and taking effect on our day-to-day work. Just say at this point that they're coming into force with very little guidance. The Ministry of Justice has taken what you could call a light touch approach and seems to be saying, well, these issues can be determined by judges, they can be dealt with by judges, and there's no other guidance really available. So for all of these new concepts, it seems that the legal profession is going to have to simply do its best. And I imagine a lot of satellite litigation is going to arise out of these different things. So I've already mentioned there's going to be a new track between the fast track and the multi-track. There's going to be an intermediate track, and within those, the fast track and the intermediate track, there's going to be something called complexity banding. So once a claim has been allocated to either the fast track or the intermediate track, it's then within that going to be assigned to a complexity band. There are 4 bands within each track, and which band a claim is assigned to a band, my apologies, which band it is assigned to dictates the level of costs recoverable for that claim. They're provided in tables in the new practice direction 45, so it will be table 12 for the fast track and table 14 for the intermediate track. Looking at which complexity band it goes into is something that the parties can agree, although given that it's going to dictate the cost recoverable, there might not be a lot of agreement on it, and in which case complexity bands are going to be stated, positions are going to have to be stated in the directions questionnaire. I'll come back to that in a moment. There is a possibility to get a claim reassigned to a different band, but only if there has been a change in circumstances and the court decides that changing it is justified. That's likely to be a very difficult hurdle to cross without something materially changing in the claim that the parties couldn't have been aware of at the time that the band was assigned. And so it's going to be really, really important for parties on both sides to make sure that they've got a really good handle on the issues and the potential issues that are going to arise in a claim, so that they can put a really strong case forward for which complexity band they want it to be assigned to, because it is going to be difficult to get it reassigned afterwards. So the new fast track, not much has changed. The the definition of when a claim is going to be allocated to the fast track has been beefed out a little bit. So still where it's small claims track is not the normal track, and still where it's not more than £25,000. It has been expanded a little to include claims for non-monetary relief, as we can see there. And then the provisions in relation to trial not likely to last for more than a day, and in relation to limited oral expert evidence, those provisions remain the same. So looking more closely at the complexity bands in the fast track, those are set out in Table 1 of Rule 2615. And I'll just pause there to say the complexity bands are slightly better defined in the fast track. It seems like there's going to be less room for argument in those than for the intermediate track. And also just say at this point that noise-induced hearing loss claims are excluded from the fast track. So looking at what those different bands are, starting with band 1, road traffic accidents where there isn't a personal injury claim, so bent metal and defended debt claims. Moving on to band 2, RTAs where there is a personal injury element, but it would have started under the protocol, so low value RTA personal injury cases and personal injury cases that would have started in the package travel protocol as well. Band 3, higher value RTA personal injury claims, employer's liability personal injury claims where arises out of an accident, as well as public liability personal injury claims, possession claims, housing disrepair, and other money claims in band 3. And then at the highest level of complexity, we've got band 4, employer's liability disease claims, other than a claim for noise-induced hearing loss, because that doesn't fall within the fast track, complex possession and housing disrepair, property and building disputes, professional negligence claims. So that's new. That might come as a bit of a shock to professional negligence practitioners, that they're going to be subjected to fixed costs on the fast track, and then any claim which would normally be allocated to the fast track, but which is nonetheless complex. So there will be a bit of room to argue that something that would otherwise be in a different band, but it's got X, Y, and Z features, and that means that it really is much more complex, and that's why it should be bumped up to band 4. So there is that ability to argue that despite the fact it looks like one of these other bands, it should actually be band 4 for X, Y, and Z reasons. So Table 12, so that's where we find out the amount of fixed costs that are going to be recoverable on the fast track. And it's dictated by the point at which the claim concludes. So if it concludes pre-issue, if it concludes between issue and trial, and if it concludes at trial. And then it's variously subdivided in those different stages, and we're going to go through those now. So if claims settle before trial, it's dictated by the value of the claim and which band it's in. So depending on the value, and then you read across and find the band. We can see there that for the simplest, lowest value claims, no costs are recoverable, which is quite alarming, and then simply read across. Where claims have been issued, but settle or discontinue before trial, it's not dictated by the value anymore, it's dictated by the stage at which the proceedings have reached. So it's divided up between issue and allocation, allocation to listing, and then listing to trial. And again, that's cross-referred with the different bands of complexity. So pre-issue, it's value and complexity. Between issue and trial, it's how advanced the claim is and complexity. And then if it's dealt with at trial, it's just complexity. We don't have anything else to cross-refer it to. We do then have advocacy trial fees. Those are dictated by the value of the claim and the band, although I will say that in each value, bands 1 to 3 are the same. The only one where there's any increase is band 4. So for example, £580 for the lowest value. Band 1 is also band 2, and band 3 for the lowest value claims are all £580, and it only jumps up for band 4. It is also possible to recover for some specialist legal advice on the fast track. It does need to be shown that it would normally be assigned to band 4. So if claims are going to fall in bands 1 to 3, these are not recoverable. We We can have post-issue advice either in writing or in conference, and £1,000 can be recovered for that. And we can have £500 for drafting a statement of case. And that's in addition to the costs that we've just covered. However, it does need to be justified. Can't just say because it's band 4, we need it. It is still need to be justified. And there's presumption we can see that there's going to be one advice, but if for whatever reason, because of the nature of the case, multiple advices are needed, that's something that the court is able to award in addition. So that's a whistle-stop tour of the new fast track and the way that the fixed costs are going to be calculated. In reality, I know that that was very fast and it sounded complicated, but when you actually open up the practice directions and look at the tables, it's quite easy just to read across and see where your case falls into. So it's relatively user-friendly, if nothing else. And now Anirudh is going to take us through the intermediate track.
Yes, absolutely. First of all, I'm just going to have a look. We've received about 37 questions during Kerry's presentation. We probably don't have a chance to go through all of them. I'm just going to have a quick look through them. I can always answer for, yes, the slide will be sent out after the webinar. So don't worry, you don't have to learn everything I've got some issues about audio. I hope that the audio is now being sorted. I hope that you can all hear me. If you can, if you can't, then continue to tell on the chat. Hopefully now, I think your audio should be good. I'm just receiving more Q&As. I can't seem to find the mouse. I just want to, because I want to check. Okay, there's more there, and in terms of that. Okay, apparently there appears to be some sort of there. Okay, all okay with the audio. Okay, we're going to proceed as normal. If anyone has any other sort of questions or any sort of queries, I appreciate it's very difficult, the finance cost regime. It's very complex in lots of parts. So this hopefully will be a nice sort of gentle store in terms of looking at the intermediate track. Now, as the name suggests, the intermediate track is really for claims which are sandwiched between the fast and the multi-track. I should also note at the start that when I refer to provisions of the CPR, I'm referring to the future provisions that will apply as of the 1st of October 2023. So that's what the provision will be. So the intermediate track is defined as a normal track where it's not suitable for the small and fast track, i.e. between 25k and 100k, where claims can be tried in 3 days or fewer with no more than 2 expert witnesses giving oral evidence, and largely it will involve one claimant against at most 2 defendants or 2 claimants against 1 defendant. And critically, this is important, especially for those who do commercial claims, where a claim includes non-monetary relief, such as specific performance, it will not be allocated to the intermediate track unless the court considers it to be in the interests of justice. Any case more complex will be allocated to the multi-track. So the slide was very interesting. What claims do not apply to the intermediate track? The first are mesothelioma and asbestos claims. Claims for clinical negligence, unless it's one that would normally be allocated to the intermediate track, and where both breach of duty and causation are admitted. I'm going to come on to that later because there are issues surrounding that. Claims in respect of abuse, harm, or neglect of or by children or vulnerable adults. It's quite funny, like last night, Kerry and I were discussing that the third provision is actually wider than general abuse claims. This is purely my personal view, but the fact that it said in respect of harm by, let's say, children or vulnerable adults, that to my mind, it could plausibly cover, say, a claim where a nurse brings a claim against an NHS trust on the basis that she suffered an assault by a mentally ill patient, and the trust can provide her with suitable training, for example. Other issues concern where claims are which the court has ordered trial by jury. if satisfied, if there's a matter in issue, and that's usually things like false imprisonment or malicious prosecution, and claims against the police involving an intentional or reckless tort or relief or remedy in relation to the Human Rights Act. Again, pausing there for those of you who specialise in claims against the police. It's not the case that just because you have the police as a defendant, you'll be exempt from these rules. It's very strictly worded. So, for example, say you have an employer's liability claim against the police. That doesn't involve an intentional or reckless tort. You would be classified under the intermediate track if it's below £100,000. Certainly, for example, let's imagine you are bringing a claim against the police under breach of confidence, for example, or misuse of private information. Well, breach of confidence is an equitable remedy, and misuse of private information, to my mind, can't really be seen as an intentional or reckless tort, though, again, there may be dispute over that, but I think it's more likely than not that it's wouldn't fall under that, and therefore would fall under the intermediate track. Gosh, we've got about 10 Q&As already. But again, the second point in relation to relief or remedy in relation to the Human Rights Act, I can see, for example, in the future, issues of, for example, Article 8 or Article 3 being tacked on at the end of claims, because that really would move the claim from what is purely a data breach claim into a human rights claim. So this whole scheme is quite complicated, and I think a really good way of just understanding how it works in practice is if we just go through a very simple PI problem that would normally be allocated to the multi-track. So, very classic RTA. A is driving a car with B as a passenger. They collide with the claimant and suffer injuries after the accident. They issue a claim against the claimant, pleaded up to £50,000. Before actually I go on, there's one point I've just noticed with the Q&As and the chat. There was a question earlier about whether product liability claims would be caught under this regime. And the answer is yes, as long as it doesn't fall under any of these categories. If the product liability claim has, say, a mesothelioma aspect, then it would be caught. But the reality is, no matter all claims that are not included within this provision, so let's say international claims, which are package travel regulation claims, claims involving the Athens Convention, Montreal Convention claims, they're all going to, if they're above £25,000, they're all going to be caught by this intermediate track, unless you can get it into one of these provisions. So, going back to this very simple RTA, what's the starting point? Well, the first thing that a court will need to consider is what happens when you have multiple claimants. And the critical CPR provision in that respect is CPR 45.5. So the way it would work is that, as normal, you would write out your direction questionnaires. You'll explain that each party, the claimant and the defendant, will set out what track they believe that the case ought to be allocated to and what complexity band it ought to be allocated to. And the court will decide, just as it does normally, first of all, the track that it should be allocated to and the complexity band, albeit they have discretion to order an allocation hearing if they think it necessary. And I think we discussed it this morning that at the start, I imagine there'll be the courts will be more minded to have allocation hearings as these reports teal in. In respect to multiple claimants, the court must consider whether CPR 45.5 applies. And what CPR 45.5 applies is as follows. In general, when you have a case with multiple claimants, each claimant is entitled to the cost of their own claim in accordance with the applicable rules. So going back to our position of Andrew and Bertha, the starting point is that you have two claimants, and both of them are, for the purpose of the fixed or recoverable cost regime, both of them are treated as two separate claimants and get two separate claims. But there are two exceptions. The first exception is where the claim is for a remedy for which the claimants are jointly entitled in order to comply with CPR 19.3. But the next exception is where, if it is in the interest of justice to do so, having regard to whether the claim of each claimant arises from the same or substantially the same facts and gives rise to the same or substantially the same issues, and the additional claimant, the second claimant, is entitled to only 25% of the principal claimant's fixed recoverable costs. Now that's different from what we normally have. And I would say there's a plausible argument, again, going back to our previous slide, there's a plausible argument for a defendant to say, and a court can order, that the additional claimant, Bertha, is entitled to rely to only secure 25% of Andrew's fixed recoverable costs because it's the same accident. So that deals with that. So let's imagine you've sent in your directions questionnaires and you're looking for various complexity bands. These are the complexity bands for the intermediate track. I'm not going to go through every single one of them in detail because they're there and you can hopefully see them. But it gives an indication of the sorts of issues, the sorts of matters that a court or a judge, when weighing up the questionnaire, will look at. I think, having looked at this matter, before we go back to our factual matrix, given that it's an RTA in which breach, causation and quantum are disputed, I would think, what do you think? I think complexity band 2 is probably a good shot. It's an issue where breach and causation is an issue, so it's not suitable. The complexity band 1, I'm the judge and the claimant solicitor and the defendant solicitor and everyone, so I can say that there aren't that many complex quantum issues. So I'm going to put it in complexity band 2. What does this mean? I'm going to pause here again just to look at the chat and the Q&A to make sure that everyone's on track. Okay, that's great. Great, thank you. Yes, we'll be discussing, I've noticed someone's had thoughts about vulnerability. I'll be discussing that as well. So let's see, we've got this. What happens next when we look at costs? So the only costs allowed are the fixed costs in table 14, which I'm going to send to you later, which will be on the next slide, and the disbursements set out in section 9. And what's interesting is that the disbursements provision under section 9, CPR 45, is very broad. Court may allow any disbursement which has been reasonably incurred, other than a disbursement covering work for which costs are already allowed in section 7. Now, I'm going to go through section 7 in more detail, but I imagine what we're going to likely to see over the next few years is essentially claimants and defendants putting in claims, testing this by putting in parts of issues as disbursements, such as potential counsel fees or potential medical expert fees. And I think the courts are really going to have to grapple with what really counts as reasonably incurred and what really counts as a cost already allowed. So moving on, there are 3 parts to this. I'm not going to read everything out because it's going to take all day. But there are 2 points which I want to raise. First of all, this is only the fixed cost for the intermediate track complexity band 2. Each complexity band has a different set of fixed costs, and therefore it's up to you to really look at the different complexity bands and see what costs entail out of that. Again, each band has its own cost matrix. Secondly, and rather unhelpfully, they're all categorized as stages, but these aren't actually categorized in a chronological order. So I'll see what I mean. Stage 1 says from pre-issue up to and including the date of service of the defence. But stage 2 includes specialist legal representatives, such as a barrister or a solicitor, drafting a statement of case. So that can actually, the costs incurred in that respect could actually occur prior to stage 1. if you see what I mean. So it's not all chronological. Most of it is, apart from stage 7 again, specialist legal advice in writing conference following the filing of the defence. But be wary, don't get caught out in just assuming that everything goes in chronologically. You have to spend some time looking through these tables to really grapple with what applies to what. And the third point, and before I go to the third point, I should note there are also separate fees in relation to ADR and approval for a settlement of a child, unless it's approved at trial. But having looked through all of this, and this is, let's not be about the bush here. This would have been a multi-track claim had it been done previously. The upshot is, I think, what all of you are thinking is that these are relatively low. These figures are relatively low in respect to it. And it's a stark reality which firms are going to have to grapple with. But luckily, Kerry and I are here to give you a sort of insight into how to start grappling with the smorgasbord. So we have the cost here. Again, I'm going to pause and look at the Q&A again to make sure I'm not missing anything. Yes, I'll move on to the clinical evidence as a later portion. So the first point, looking at counterclaims and other applications, this is the one part of the rules which is actually quite simple. If a counterclaim is successful, then the fixed recoverable rules apply as if the counterclaim was a claim. It obviously doesn't apply if the counterclaimant is just a defence to the claim and not actually seeking any remedy. Again, that would be quite bizarre if a defendant could simply put a paper counterclaim and just try and get costs that way. Applications have costs of £333 or £250 in that respect. Right. This is one of the flies in the ointment. Vulnerability. The reality is, under the present rules, there's quite limited scope for increase of cost when it comes to vulnerable clients. And in fact, it's only been relatively recently that the needs of vulnerable clients have actually been considered by the courts. We recently had CPR Practice Direction 1A to provide guidance on questions of vulnerability. But the reality is that if you have a vulnerable client, and the definition of vulnerability and the sort of ideas you can think of, they're in CPR PD 1A. If you have a vulnerable client, then you can get an increase of costs at the end of the trial, but only where the party or witness is vulnerable, we prove vulnerability, you need to prove that that vulnerability has required additional work to be done. And by reason of that additional work alone, the claim is for an amount that is 20% greater than the amount of fixed recoverable costs. Now, I don't know about you, but that's a very high test. By reason of that additional work alone, there needs to be, you need to prove it. And it's a constant state of proving things to the court. And there are plenty of issues with this, which I'll explain with later. The next other issue is unreasonable behaviour. And this is quite similar to the indemnity provisions that we have currently. It's possible for parties to apply for fixed costs to be increased or reduced by 50%. Of course, this is a very high bar. It's unreasonable behaviour for conduct which there is no reasonable explanation. Now, if life wasn't difficult enough, we have changes into Part 36. This is actually beneficial for the claimant in this respect, because in some cases, it's been quite difficult to see the difference between indemnity costs and standard costs. But now, where a claimant beats their own Part 36 offer at trial, instead of costs assessed on the indemnity basis, they will be entitled to claim these additional costs, being 35% of the difference between the fixed costs, the stage applicable when the relevant period expires, and be the stage applicable at the date of judgment. So it does at least put the claimant in a better position, in my view, when it beats the Part 36 offer compared to the status quo. Again, I'm just pausing here to look at that. I do appreciate there's questions about Part 8 claims and things like that. They'll be dealt with at the end. Sorry, I just need to make sure there's a lot to get through, but just to clarify, we haven't dealt with, we haven't ignored that in that respect. So, as you've all seen, there are a number of issues with the fixed cost regime. And in light of, if you think there are issues, you're not the only one. The Association of Personal Injury Lawyers has issued a judicial review against the MOJ in respect of another number of issues. And I'll go through this step by step. Ground one is in relation to clinical negligence claims. I noticed there are a few issues at this point, so I just want to clarify something. Under the present status, claims for clinical negligence, unless the claim is one where it would be normally allocated to the intermediate track and where both breach of duty and causation are omitted, are caught under this provision. I remember there's another proposal by the Department of Health for claims under £25,000 that hasn't been introduced yet. I believe it's still in the middle of consultation, but that's separate to what we're dealing with now. But if we think about that, claims for clinical negligence where both breach of duty and causation are admitted, there's a fundamental problem. And that fundamental problem is as follows. There's no guidance or nothing to circumscribe when that breach of duty and causation is admitted. So theoretically, does that mean that if a defendant admits breach of duty and causation the day before trial, does that move to, can the claim then be reallocated to fixed costs? And also, just to say that there's an admission of breach of duty and causation doesn't differentiate between partial and full admissions. And I'll give an example. So let's imagine you're acting for a claimant in a clinical negligence claim, and you have primary and secondary cases based on various breaches and based on the causation hypothetical. So you say there's a breach for, if there was a breach and breach of paragraph 1A or of a particular breach and causation, then what would have happened is that the claimant would have avoided 1 year of avoidable pain and suffering. That's our primary case. But we have a secondary case that a claimant would have at least suffered 1 month of avoidable pain and suffering. Now, what happens if a defendant admits the claimant's secondary case in terms of breach of duty and causation, namely the 1 month of pain and suffering, but still leaves the primary claim in issue? Well, breach of duty and causation have been admitted, but there's nothing in the rules that says that it shouldn't, that it doesn't go back to the intermediate track. There's a lot of ambiguity about the clinical negligence claims, which really will be addressed I suppose, in the judicial review. The next issue to consider is that of the lack of support of solicitors dealing with vulnerable clients. There's a real concern about access to justice, not only with the provisions that I enter later, but also because what was clear is that the vulnerability provisions occur at the end of the case, not before. So you only get your costs at the end of the case when you're proving that. And that's different from what we saw on multiple claimants when it was dealt with at the allocation stage. So really all the costs have to be incurred before the judge makes a decision about whether they can be recoverable. There's a real concern, I say, with access to justice, and especially in cases like Santiago and the MIB, where a new focus has been on vulnerability. There's a real concern that vulnerable claimants may be shut out as a result of this. The third point is that at present there is nothing on the recoverability of inquest costs or the costs of restoring the company to the company's register. Now, to their credit, the Ministry of Justice has recognised that there's an issue. Nothing has changed in the rules as of yet, but I imagine we will hopefully see some movement. And finally, there's no provision to allow parties to contract out of the fixed cost regime when there's a dispute in a settlement agreement. This seems to me to be a remarkable encroachment on freedom of contract, and one which wasn't even consulted on. So Kerry and I have been dealing with all the problems that come out of the fixed cost regime. But I want to end this almost on an optimistic, happy note, even though we've been Mr. and Mrs. Doom and Gloom for the past hour. What can you be doing between now and the 1st of October to put your clients in the best position? The first point is that if you have a claim which doesn't include personal injury, and it would normally be allocated to the multi-track, then you should really seriously consider issuing prior to the 1st of October. Do not wantonly delay. Similarly, if you have an industrial disease claim, such as repetitive strain injury, and it's not necessarily over-based, then you should really send the letter of claim as soon as possible, dispatch it as soon as possible, and before the 1st of October 2023, otherwise you're going to get caught up in the intermediate cost regime. The second point, and this is something that's been dealt with by other practitioners, Kerry, Anirudh, James Miller in particular, is that in advance of these reforms, you really need to consider and check your retainer and client care documents. Financial pressures, particularly on claimant firms, are going to increase. And it would be reasonable to assume that some of these firms will make up the shortfall by claiming it back from their clients. And it's really likely to generate client solicitor disputes over the shortfall overall. So we're likely to expect to see more cases similar to Belsner type cases in the future. The way you prepare for this is to review your retainer, review your client care documents, explain to your client about the tables, you can use our presentation if you wanted, to make sure that the clients are aware of the risk of the shortfall. The client really needs to provide informed consent, otherwise you run the risk of running into long-headed satellite litigation. And the third point are the tactics that defendants can use. The real battle is going to be about the complexity bound, because that will really make or break cost recovery, especially in relation to things like travel claims. The defendants can make tactical admissions to reduce the complexity of the claim or put it into a lower band. And that's something that defendants are likely to really consider, to think about. So that really ends our whistle-stop tour of the fixed cost regime. You'll have both our emails there, so you can make comments. How much time do we have left for questions? Let me just check.
15, 20 minutes.
We've got 15, 20 minutes, so we'll go through questions. First of all, by the way, you've all been very patient while we've been rattling through this. In relation to first point, the first point about Part 8 claims. With Part 8 claims, I think it often depends on what the Part 8 claim is, because if it's a Part 8 claim under Practice Direction 49F, there are provisions within the CPR which fix that. But in relation to Part 8 costs-only claims, it hasn't really been dealt with in the rules which implement the extended fixed recoverable cost regime. And the Bar Council are actually consulting on it. If you want to, you can email either me or Kerry about maybe a particular situation, and we can provide more specified advice. There was another one. I'm sorry, I'm talking over you, but if you want to grab in on all these as well. Okay, the hourly rates. The hourly rates, this is one point that's important to recognise. The hourly rates have previously changed from 2021, but the whole point of the fixed cost regime is that they're irrelevant, because now what matters are the charges within the bond, within the tabs. You just go back. What matters, to give an example, are these figures. So, as Kerry Underwood said, is brilliant blog, which you should all visit. Guideline hourly rates, irrelevant. The seniority of the lawyer, irrelevant. Time spent, irrelevant. Indemnity principle, irrelevant. Budgeting, irrelevant, unless you fall into one of these exceptions. This is why this is a revolution in cost law. It's, for those of us who do PI or PI-related claims, we're used to it being in the fast track. But now it's extended across the board to much more complex claims. Kerry, do you want to?
Well, there's a question here about what is the position in the pre-action protocol period if a letter of claim is served before 1st of October? Do the old rules apply? That will depend on the type of claim. So we said earlier that the letter of claim being served before the 1st of October is relevant for disease claims. I'm not sure if that's answered the question. But 1st of October is relevant for letters of claims only for disease claims. For personal injury claims, it's relevant for the date of accrual, and then for all other claims, it's the date of issue. There was one, I think this is for you, Anirudh, because I don't have different stages. So are the fixed costs cumulative for each stage? So, for example, the ones that are on the screen now, do you add those up, or are they? Is that all that you get?
So my understanding is that they're cumulative based on where it is at trial. If we just go back to them. Yes, I need to. So my understanding is that it's cumulative, otherwise it could lead to quite bizarre results. But it comes back to the point I said earlier, is that they're not in chronological order. So you need to work out in some ways which, if you haven't got a specialist legal representative providing the post-issue advice, that obviously falls away. My understanding is that it's cumulative, but yes, that's my view in that respect. That I think in relation to clinical evidence claims. And the ones that are below £25,000, that's a separate Department of Health claim, I believe.
In relation to vulnerable third parties, so presumably witness, allow us to avoid intermediate track, or is it only the claimant? That's
a really interesting question.
That sounds like you don't know the answer.
Yeah, a lot of these questions are. Let me just go back to the vulnerability provisions. Well, no, so yeah, a party or witness is vulnerable.
But that's in relation to the amount of costs recoverable rather than the allocation of track.
Yes, rather than the allocation of track.
We don't know the answer to that one off the top of our head, but we are going to keep these, and we will send out when the presentation is going on. We're going to have a look into them, and we can answer whatever ones we can't answer now.
Yes.
So if because of time or for some, or because we don't know yet,
yes,
we will still answer those questions. So I'll have a look into that one. That's it. Ignore.
Yeah, has anyone ever come across an instance in history where a court has actually read a directions questionnaire before ordering direction?
I think that will have to change. I think
that's going to have to change.
I mean, the box work.
But for all of us who are travel lawyers, we've seen time and time again where parties have agreed local standards report is required, and the court just hasn't really taken notice of it, and it's required an additional application. It's going to have to change.
So yeah, I think directions questionnaires.
The chat as well.
It's going to be quite different. Just to finish this. So there's a question what happens about barristers' fees. Hopefully that's been covered. So depending on the type of fee and depending on the track and the bands, those have been prescribed. What haven't been covered are abated trial fees. That's not yet been dealt with. I think was part of the MOJ consultation.
Yes.
But for the most part, barristers' fees have been either provided for or not. There's a question about part 36, if you beat it, will you get indemnity costs and take you outside of the fixed cost regime? No. If you beat it, you no longer get indemnity costs. You get the 35% uplift calculated from the end of the relevant period. The indemnity cost falls away. Yes, that's side. Okay, so then in the chat. So this is a slightly longer question. So, Bethany, you put in a slightly longer question about costs jump between pre-issue and post-issue. I think that's one that we'll have to go in, read a bit more carefully and be able to answer by email.
Yes. Again, if you have any further questions, the slides will be sent across to everyone. So feel free to send us emails, comments, or if you want to vent about how all of these reforms are. Yeah, so the cumulative point. Yes, this is what comes for doing off the hoof. I think with the point, someone's just raised the point about cumulative. I think it depends on the stage, and it depends on where it comes from. If someone sends an email, I can send me an email about this. I can go into a bit more detail because I recall there are parts which are cumulative, but there are parts which I think won't be. I think
you very kindly opted to take the intermediate.
Yeah,
the fast track are a lot more simple, and you don't have these different stages set out like that. It's a much simpler table. So I think that might be something because it's not immediately apparent. So that might be something that you need to
have
a look into. And then, yeah, can you give an example of part 36 cost uplift? So where is that slide on?
So that slide would be
there.
So that would be the additional cost uplift. So it'll be 35% of the difference between the fixed costs at the stage applicable when the relevant period expires and the stage applicable at the date of judgment.
So you would take, trying to think it through.
Yes. So if we take, for example, let's imagine you have a pre-issue Part 36 offer, so £5,000 plus 6 plus in damages, and let's imagine you have, I'm doing this on the hoof again, then in that case, when you've calculated it all together, stages 1, 3, 4, 5, and 6, say, and then you get to trial, then if you communicate them all together, and then take away the total from what was originally done at stage 1, and then times it by 35%, that would, I believe, constitute the uplift. Again, all of this will be on a case-by-case basis, because a lot of it, so much is dependent on the damages as well.
Sorry, just scrolling through and not miss any questions. So there's a question about for an RTA, where liability is disputed and there may be jurisdictional and or applicability issues, which is worth less than 25k. I think that's one of the ones for, it's been asked what band that will be assigned to. Probably fast track band 4, because the complexity would lift it up.
Yes, it's funny, because if that was on the intermediate track, and we go back to the intermediate track, yes, it's not quite clear what counts as a serious issue of fact and what is a serious issue of law. It doesn't, and it uses the word serious, not significant.
Yes, so I mean, this is the problem that, and it's less clear on the intermediate track, but we don't have any guidance for what all of these new definitions and things mean. So there is going to be a lot of scrapping, especially at the start, trying to convince judges in relation to allocation as well as the complexity.
Yes, and that's why I think district judges will put forward allocation hearings at the start as this new regime enters, because I think there is so much dispute and because there's so much ambiguity.
And we've got a question from Arif about denying liability. So when denying liability for claims, I usually deny issues of liability causation, both factual and medical, and on quantum to ensure there is a comprehensive denial. Does the panel think that once the extended fixed costs rules come into force, that would generally be better to deny on one issue only, to ensure that the matter is assigned to the lowest band in the first instance? Or would it be the case that if you don't raise other issues, then by remaining silent, you run the risk of the claimant issuing an application for a higher band anyway?
Well, if it's tactical, it depends whether it's the point I raised at the end, that it's about tactical admissions, and whether it's band one, whether if you have a plausible, particularly weak case on breach, it may be worth, in a clinic claim, for example, making a tactical admission of maybe one aspect of breach in order to persuade a judge that actually this is a case which goes into complexity band 2, not complexity band 3.
So fixed costs include disbursements, e.g. expert reports, court fees and counsel fees. So expert reports haven't been dictated, they haven't been fixed.
No,
so they're notably excluded.
Yes, my understanding with expert reports was that would constitute disbursement rather than a fixed cost.
What time are we on?
I mean, there's more kind of questions flooding in as well.
So agreed special damages can bring a multi-track claims into the new intermediate track. Can this also work to bring intermediate track claims into the fast track? Yes, I think so. So for allocation, when you're assessing the value of the claim for allocation, you discount for what's been agreed. So when you're looking at the value, it's only the value that's in dispute.
Yes.
So yes, that would work. So if you're able to agree a big chunk of it, yes, that would work. So yes, so it's a way, if you're able to realistically, you're going to lose on something, you can bump it down from the intermediate track to the fast track. We've covered that one. I think is that. So will a defendant be entitled to the same uplift if the claimant fails
to beat a Part 36 offer that the defendant has made?
It is. This is the thing about creating a presentation for hour. There are so many different ambiguities. There is provision for defendant Part 36 offer. Again, I will need to check. If you email me separately, I'll check for you.
We can get those questions, but I had understood it that the only bit of Part 36 was changing, was not indemnities, it was shifting to this 35%. But we will check that. We'll check that. Okay, so what if a Part 36 offer is made at the very end of one stage and then the relevant period falls into the next stage? It's the time starts to run. So the time starts to run in the same way from the end of the relevant period. So that's something that you're going to need to take into account, although it'll be difficult because it's not always clear when a stage is going to move. You don't know necessarily exactly when a court's going to allocate your claim. But the fact that it's based on these stages, it really provides even more of an incentive for claimants to issue sensible Part 36 offers early on, because the earlier the stage you get into, obviously, the bigger the uplift is going to be. But the relevant stage is not the stage that the offer was made, it's the stage that the relevant period expired, the same as now. I think that's most of them. And the question was, okay, thank you, James. You've dealt with one of Anirudh's questions. I don't know if you want to take that. So the cumulative question.
Yes, one thing to raise about everyone, there is a very helpful MOJ note on each of the rules that says that the costs for each stage include costs for earlier stages. Yes, that's clarified.
Yes, that's it. It's not cumulative then. I think that's it. As I said, there's been a couple of questions that we haven't been able to answer. Oh, hang on, we've got another one. Would raising fundamental dishonesty amount to a serious issue of fact? It could do. Judges very much have their own approach to fundamental dishonesty between them. It's dealt with differently by each judge, unfortunately, but there would definitely be space to argue that we've raised fundamental dishonesty. And we think that this raises it up because it's an allegation of fraud, but it's dealt with so often, and county court judges are very, very familiar with dealing with allegations of fundamental dishonesty. It might depend on the nature of allegations. So simply raising it and saying, oh, well, there are a couple of inconsistencies, so we think we're putting you on notice that we're pursuing fundamental dishonesty, that might not be enough. Whereas if you can point to a lot of sort of very detailed evidence and say, well, we think he's dishonest for X, Y, and Z, then it might do. I think it's going to be very fact dependent, but it is certainly an issue where there's scope for argument that it should be bumped up to into band forward because fundamental dishonesty is an issue. But it will really depend on the case on the basis for which fundamental dishonesty is being alleged. What tips and tactics would you recommend defendants to explore?
I think tactical admissions would probably be, because ultimately the way you make or break the case is, in terms of costs, is on which complexity band is allocated. And a tactical admission is probably the best way of shifting it, something from complexity band 2 to complexity band 1, or complexity band 3 to complexity band 2. And
similarly, not raising loads and loads and loads of issues in the defence. So belts and braces, everything but the kitchen sink goes in, because if you do all of that, when realistically you know that there's a couple of things that are really central, and all of this is just getting pleaded for the sake of a very, very comprehensive approach, the claimant will then turn around and say, oh, look, well, they've brought all of these things into issue. That means it's really complex, so it needs bumped up. So really thinking both about admissions and what you're actually going to be relying upon, and not chucking in absolutely everything to be on the safe side, even though in reality you know that some of it's going to fall away, because that will then give the claimant in their directions questionnaire the ability to say, well, the defendant says, oh, we have to prove all of these things. That means it's really complex, and that means it should be in band 4. Yeah. One last question. I think that's for you, Anirudh.
Yes, do you interpret the stage 2 counsel fees in relation to statement claims mean you wouldn't be able to recover a particular claim drafted pre-issue as opposed to?
Well, I think that's me. I think that's in relation to the specialist legal advice. So drafting a statement of case. So in the phrasing of it, it's not clear. The advice is post-issue, but it's not clear whether or not it also requires the drafting statement of case to be post-issue. The way that it's phrased in the rule is not explained. So that, I'm sorry, there's not an answer. It's slightly ambiguously phrased. Obviously, if it's a defence, it's going to be post-issue, but in terms of particulars of claim, it's not clear. Great, well, I think that's everything, and we will get back to the people that we've not been able to provide answers to, along with slides should be available as well.
Exactly.
But thank you very much for everybody for attending. I hope that helped you understand somewhat, but the takeaway is there's a lot of change and there's been very little guidance on it, and it's going to be a learn as we go along for everybody, I think, including judges, unfortunately, on this one. But thanks very much for coming.
Take care.